to deliver over 150 grams of heroin. The conspiracy allegedly occurred between April of 2018 and September 5th of 2018. And at the trial court level, all of the parties were in agreement that the conspiracy was cut off on the September 5th date when the two other co-conspirators were caught by police. They decided to cooperate and became essentially CIs and were accomplices for the purposes of Mr. Fuller's trial. But so that wasn't really briefed, but I do think that that is correct, that the September 5th deadline sort of cuts off the conspiracy at that point. So anything that occurred after September 5th, the parties were in agreement that occurred outside of the conspiracy. So I do want to mention, obviously, part of our argument is that the accomplice corroboration rule was not met here. I do want to, of course, acknowledge the Supreme Court's decision last week of abolishing the accomplice corroboration rule. However, the Supreme Court did rule that that is a prospective decision, not a retrospective decision, and since Mr. Fuller's case commenced well before that, at the time that we proceeded to trial, that was still good law, and the state had that initial burden to reach in this case. So there are really two issues in our brief, but I do think they sort of dovetail together. So number one, our sort of umbrella issue is that the evidence was insufficient to sustain this conviction for multiple reasons, including the accomplice corroboration. But separately, although I think it sort of ties into it, that the evidence of the September 7th meeting and controlled by should have been excluded under 404B. I'll start with the September 7th by, and then I'll go back to the sufficiency. So as I said, there was no argument between the parties that the September 7th controlled by occurred outside of the conspiracy. So already we're under other crimes or bad acts. The accomplices were contacted by police to set up this September 7th controlled by with this individual that they knew as 50. They met that individual in Mr. James, I believe they drove in Mr. James's vehicle to meet this person. The car was outfitted with audiovisual capabilities, but for whatever reason, the placement of the camera was not right, and they were unable to identify the individual in the other car. And that was the catalyst for the setup of the September 21st buy. Because they were unable to identify the individual, they asked the CIs to go back, do this again so they could get a full and complete identity of the individual in the car. And yet, at the trial, the state attempted to introduce evidence of the September 7th buy to prove identity, even though everyone was in agreement, and the video is in the record for your honors to look at. Everyone's in agreement that you cannot see the individual in the other vehicle. And
can you hear anything?
I listened to it.
How is it identity? How is it they go to identity?
Well, that's our argument, is that this is not evidence that could have been introduced for identity purposes, because you absolutely cannot see the individual, and I don't even really think that you can hear all that well. You can hear Mr. James very clearly, but you cannot hear the other individual.
Wasn't there something significant about the vehicle that was being used that connected the identity of the defendant to that vehicle?
So you can see a partial vehicle, the front bumper, I guess, of the vehicle is visible. One of the officers testified that he was able to ascertain that that vehicle was a Jeep Grand Cherokee, and that is, of course, the vehicle that was present at the September 21st buy. But I don't think that alone, the vehicle itself, without knowing who's driving that vehicle, is enough to establish identity, especially when Ayers and James both testified that they knew Mr. Fuller or 50 to meet them in different vehicles, that they met with other individuals at times, that when they would go to do these transactions, he was not always the person that they met with. So the vehicle itself is not enough to establish that it was Mr. Fuller driving the vehicle, even if he was the person behind the wheel on September 21st.
Did Mr. Ayers and Mr. James ever know that your client's name was Fuller?
I don't think that they were aware of that until trial. They only knew the individual as 50. There's no testimony that they knew, anything besides a street name.
So identity was a pretty big issue, it sounds like.
It was, yes. And so and we acknowledge, I think at the trial court level, we did initially argue that maybe the September 21st evidence should also be excluded. I do think that there's enough there. One of the officers saw the window roll down, was able to identify Mr. Fuller as the person in the vehicle. But that September 7th date, I don't think that there's anything there that specifically ties Mr. Fuller to that transaction. There's also some discrepancies as well in that Mr. Ayers and Mr. James testified that typically when they would have these transactions, the narcotics were exchanged in a sock. In this instance, they were exchanged in a bag, a plastic bag, and you can see that in the video. So that is also something that goes towards, this is not solid evidence to prove identity. And the state in its brief doesn't really engage with sort of the trial court's rationale for introducing this under the identity prong. The trial court seems to indicate that it was introducing this evidence under the common plan or scheme exception. But this isn't, drug sales are not typically like signature crimes. And again, maybe if the drugs had been exchanged in a sock, as they said that they had been typically, then maybe we might get a little bit closer to that common plan or scheme. But because it's never the same vehicle, the transaction looks a little bit different, I don't think that it would qualify for that common plan or scheme exception. And as far as intent, again, the state doesn't really try to support the trial court's decision there, but I think before we can even get to intent, we've got to establish identity. And if we can't reach that initial hurdle of establishing identity, then I don't think we can even get to this goes to prove intent. And of course, intent, with this being an inchoate crime, is also very important to the state's case. And that's really why this is not harmless. Because this was charged as a conspiracy, it's sort of unusual in the sense that all of these transactions occurred in Davidson County, and yet this was charged in Rutherford County. There's no evidence in the record that Mr. Fuller ever stepped foot in Rutherford County, just that the transactions that Ayers and James carried out occurred in Rutherford County. So because this is charged as a conspiracy, and that intent piece, the meeting of the minds, is so important. I think introducing evidence of these multiple drug transactions, in essence, it allows the state to sort of clear a hurdle without actually having to prove that meeting of the minds. If they can show we have a September 7th buy and we have a September 21st buy, then we get a lot closer to saying, well, there were multiple drug transactions, so the jury can almost sort of infer that there was obviously some sort of meeting of the minds here, without the state actually having to prove that intent piece. And that's part of our argument in terms of sufficiency as well, that while the state absolutely probably proved that there were multiple drug transactions between Mr. Fuller and these other two gentlemen, there's nothing in the record to support that meeting of the minds that is so critical to a conspiracy conviction. In fact, Mr. James, I believe it was actually both, Mr. James and Mr. Ayers, both testified about this critical point that the state really hung their hat on at trial, this moment where they were initially fronted the drugs. The state really, in the trial, focused on that as sort of the moment that this became a conspiracy, that there was some sort of tacit understanding between these three people, that they were going to then take these drugs and then sell them into Rutherford County. But even by Mr. James and Mr. Ayers' own testimony, the reason for the fronting of the drugs had nothing to do with any sort of agreement about selling these drugs. What happened was that initially Mr. James and Mr. Ayers were coming to this individual 50 a couple times, maybe 2 or 3 times a week, to purchase drugs for personal use. At some point, that increased to every day. And both of those men testified that 50 grew sort of frustrated with the fact that they were making these frequent visits every day, and said you can't come every day. And you can understand why someone would, be reticent about having drug transactions with the same person every single day. So he says you can't come out as often, and that is the point that he decides to front them more drugs so that they're not coming every day. Takes the picture of the license, which the state did, make a big deal about that this was like the smoking bullet, that he took a picture of their licenses and now they're all sort of in this conspiracy together. But even, I believe, Mr. Ayers testified that he believed that the reason for that was essentially to ensure payment. That he took a picture of their licenses, so now I know where you live, I'm giving you additional product, and I expect to be repaid for that. And if for some reason, you go off and I don't hear from you again, I know where to find you to get my money. But so even with the state's own witnesses, there's not this testimony of a meeting of the minds. Even they are saying this incident was about us getting additional drugs for our own personal use to cut down on those frequent trips. So essentially there are I think several different ways that the state did not reach its burden of proving the sufficiency of the evidence, but the one that I do think is most salient is the fact that there was never this meeting of the minds. I think there's a lot of discrepancies in the testimony, and obviously we've cited a lot of them in our brief, that there's a lot of evidence of several drug transactions, but several drug transactions is not a conspiracy. You do have to have that meeting of the minds, that all three of them decided that they were going to get together, that Mr. Fuller either directed or instructed them to go out and do this, even if that's tacit, but we don't even have that. We have nothing indicating from any of the witnesses that there was any sort of discussion. He's not asking them, how's it going? Who are you selling to? None of that discussion is there. They're having these transactions. He gives them an amount. He tells them, this is what you owe next time, and it continues like that. But there's nothing in the record to indicate that there was ever a meeting of the minds between these three individuals. And without that, that's the linchpin of a conspiracy conviction. And without that, the state has not met its burden. And I think I went through that very quickly. So if there are no further questions, I will leave it there, and I will wait for a rebuttal. Thank you, Your Honor. Thank you.
Thank you.
For one more minute, good morning, Your Honors, and may it please the court. Ronald Coleman on behalf of the state. This court should affirm the defendant's convictions because the evidence overwhelmingly established his guilt of conspiracy to sell at least 150 grams of heroin, and because the trial court properly exercised its discretion in admitting these two other interactions to establish the defendant's identity. And so it seems like I believe the defendant took those in reverse order, and I'll do it the same. The trial court properly exercised its discretion in admitting these acts, especially admitting the singular act. The only act that is currently being challenged is the September 7th interaction. And I think I fell into this mistake in my brief as well by calling it a controlled buy. This was not a buy. This was paying back the defendant. He ended up throwing them more heroin, but it was not an intentional buy. And I think that's important here because that is, I'll get later to why that establishes the conspiracy. But the court properly found that this was relevant to establish identity. And I think Judge McMullen and Judge Easter, you both had questions on how does this September 7th interaction help to establish the defendant's identity? Because I think on its own, it doesn't. The defendant correctly asserts you can't really see who's driving that vehicle. You can't tell what kind of vehicle it is, but that in and of itself, sort of in a closed universe, that wouldn't establish identity. But what we have here is the testimony of the two accomplices, James and Ayers. They said they knew the defendant, or they knew 50, who is the person who was the one giving them all of this heroin. And while they did go and buy for personal use from other individuals, My reading of the record is that 50 is the one who fronted them the massive amounts of heroin, and 50 is the one who they entered this conspiracy to sell with. And they knew 50 to drive several vehicles, but at the end, whenever these two individuals were arrested by police, they knew 50 to drive a white Jeep. And so then the day after they are arrested, they call up this person that they know is 50, and they discuss, we owe you this much money. And the defendant doesn't challenge that coming in, where this person on the phone says, yeah, you owe me a little over $10,000, negotiates it down. You can pay me $9,800, and we'll meet tomorrow and we'll get this. And they arranged that deal for them to pay back some of the money. And at that September 7th interaction, somebody, the same person who they purport to call 50, drives up in a white Jeep. And again, you can see the white Jeep on the video, and an officer testifies, I saw this car that came up to them. It was a white Jeep Grand Cherokee. They didn't get his face, they didn't get his license tags, and so they arranged a second meeting. And at that second meeting, which is the September 21st meeting, which the defendant does not object to on appeal, an officer was able to see the defendant's face and identify this person as the defendant. It was still a white Jeep Grand Cherokee. They were able to get the license plate tags off of that white Jeep, and those license plates tags ran back to the defendant's mother. And so when you combine all of that, the fact that these two accomplices knew 50 to drive this Jeep, that when they arranged this first interaction, a person in a white Jeep drove up, and that when they arranged another interaction, a person in a white Jeep who is now positively identified as the defendant and who is now tied to that white Jeep via the rental agreement, that helps to establish 50's identity as the defendant. And so for that reason, the trial court properly determined that this was admissible to establish the defendant's identity as 50, as the person who was giving them these massive amounts of drugs. If there are no further questions on the admissibility of that evidence, I'll turn to the sufficiency challenge. And here the evidence overwhelmingly established the defendant's guilt. I'll take some of the defendant's points, sort of point by point. First, the defendant claims that he was never in Rutherford County. He was always in Davidson County. So how could he have a conspiracy to sell these drugs in Rutherford County? And the proof there is that the defendant took these pictures of Ayers and James's licenses that had their addresses as being in Rutherford County. And Ayers and James also testified that when they were arranging a meet with the defendant or with 50, they would say, we're 45 minutes out, we're coming up from Murfreesboro, or we're 45 minutes out, we're coming up from Laverne. So the defendant had knowledge that these individuals lived in Rutherford County and were doing their interactions in Rutherford County. The defendant really heavily hits on the fact that there was no meeting of the minds, and says, that he never questioned what they were doing with these drugs, and the fact that he took these pictures of the licenses were just to go and get back at them. But respectfully, Your Honors, a drug dealer does not front money to someone for personal use. The jury was entitled to infer that when the defendant started fronting these drugs and simply saying, pay me back, you owe me this much money, taking pictures of licenses, that was entering into a conspiracy to sell those drugs. And I think it's important also to look at what James and Ayers testified to. They were going multiple times and buying for personal use, and then at some point the defendant began fronting them these drugs. But it's the amount of drugs that is really critical here. I think James testified it went from 4 ounces to hundreds of grams. I think he said 200 grams at one time. And so that simply is, and I think there was a testimony, but even the fact is, 2 individuals cannot use that much amount of money, or that amount of heroin in such a short period of time. They were still having these meetings every couple of days. And
well, is there any testimony in the record between these two that they were meeting with the defendant to sell his drugs in Rutherford County?
I think a rational jury could find it. There's no
direct evidence of that.
There was nothing direct of one of either James or Ayers meeting with the defendant and saying, hey, thank you for giving us these massive amounts of drugs. We're going to go to Rutherford County and sell them. That's not in the record. But the jury could infer that based on these interactions, the defendant knew they lived in Rutherford County, knew they were always coming up from Rutherford County, and gave them, again, upwards of 200 grams at a time of heroin every couple of days.
Well, again, it's sort of the same argument that we hear a lot. Possession with intent to sell or deliver can be based upon the amount. I get that. It just seems that they would have testified they were selling it for the defendant.
So James and Ayers testified that they were selling it for the defendant.
Okay.
They thought they had this agreement. There's no direct testimony that they explicitly told the defendant. So
okay.
This is inferences the jury has to make as to whether the defendant was aware of this meeting of the minds. The state's position is that the proof presented at trial readily establishes that the defendant was aware they were selling these drugs and had entered into this sort of implicit agreement to sell these drugs. Again, the defendant pointed out that really the only reason that these drugs were fronted was to cut down on frequent trips. But again, the evidence just belies that. 200 grams fronted is not solely to cut down on frequent trips. And again, James and Ayers testified that even after the drugs were being fronted, they would still visit the defendant every couple of days. So the evidence overwhelmingly establishes that the defendant, I think lastly, I'll talk about this corroboration. And as this court is aware, the Supreme Court recently released Thomas and Turner. I don't think that has any effect on this case. I think our readings of that opinion are that that is prospective and not retroactive. So there was still required to be corroboration of James and Ayers' testimony. But it's important to note what that corroboration has to be. And there's two things that is needed to corroborate accomplice testimony. One, the inference that a crime was in fact committed, and two, some fact establishing the identity of the defendant as a criminal actor. As I've already sort of belabored under the 404 analysis, the proof established the defendant's identity, and so that portion was corroborated. And then the fact that a crime was committed was, again, also corroborated. Police officers conducted numerous buys from James and Ayers. That was the crime. That corroborated their testimony that they'd been doing this for a while. So there was overwhelming corroboration, overwhelming proof, and the evidence established his guilt. If this court doesn't have any further questions, we respectfully ask that you affirm the judgments.
All right,
Thank you.
Two very quick points, Your Honors. First, the state seemed to mention that these individuals knew 50 to be driving a white Cherokee. There's actually testimony at the trial that Mr. Ayers said that I knew 50 to have several nice cars, but at the time that this was occurring, I actually knew 50 to be driving a Camaro. So again, we go back to there are several vehicles involved in these interactions. And again, there was testimony that even when they would meet to purchase drugs from 50, it was not always 50 who was delivering those drugs. So again, I think that goes to the sufficiency of, we have a lot of moving parts here, and it's interesting that the September 7th and September 21st buys, in a lot of respects, look very different than, or meetings if they're not buys, but they look very different than what Mr. Ayers and Mr. James testified had been going on for the span of several months. That all of a sudden he's showing up in different car, the same car twice, even though they knew him to be driving several different vehicles. We do not know if the person that they met with on September 7th was the same person they met with on September 21st, just that it was the same vehicle, but we don't know for certain that it was the same individual because the image is obscured. And finally, to Judge Easter's point, there are two individuals who testified at this trial who could have explicitly said, we understood that we were taking these drugs to then go turn around and sell them to other people. Neither of the witnesses ever explicitly stated that. There's no testimony that they had a conversation, even with each other, that, well, okay, now that we've got all these drugs, we've got to go and turn them around. There's no testimony about that. And you would think that when intent and the meeting of the minds is the crux of the state's case, if they have two individuals who can explicitly say, we had a conversation either with the defendant or with each other, that we now have to turn around and sell these and push them out elsewhere, neither of those individuals testified to that fact at trial. We have a lot of inferences. I think the state is trying to sort of pick up on all of these inferences, ultimately lead us to that point. But I don't think there's any testimony explicitly. And really, I think because of all of the discrepancies between all of these interactions, there's nothing that explicitly says there was a meeting of the minds between these three individuals and that Mr. Fuller was directing these two men to travel back to where they were from in Rutherford County and go and to sell and deliver these to other individuals. So we would ask the court to reverse the conviction and vacate. Thank you.
Thank you. Thank you both for your arguments today. I believe that concludes today's docket. Is that correct?
Yes, Your Honor.
We'll be in recess until 9:30 in the morning. Thank you.
All right.